everybody. We're recording this a few days after the landmark Supreme Court decision that has forever changed abortion law in America, and that's why that decision matters. Abortion law can go in a lot of different directions from this point on, and we can't anticipate the future, but for now, this is an important moment. It is historic because the Supreme Court decision overruled past Supreme Court precedent that placed abortion underneath the umbrella of a constitutional right and put it back under the awning of the state. It's summertime here in Texas, so I'm thinking a lot about shade. And that's one way that you could think about how has this decision changed? Well, at first, this idea of abortion, the policy of abortion, fell underneath the extended shade of the Constitution, according to the Supreme Court. But now the Supreme Court is saying that is not the case, that it actually falls underneath the awning, the purview of the state. And that's why it matters. That's why this change really matters. Obviously, this has sparked a lot of talk and a lot of debate and a lot of emotion. And I'm glad we've had a few days to think a little bit about this, to think about how to be smarter on this particular topic and more thoughtful and value-driven, because that is our mission as Smarter News. I've spent a lot of time listening to you and your questions. By the way, you're asking all the great questions that are out there. All the great questions that any journalist can ask, you are asking. So I just wanted to pass along that compliment. Absolutely. And I've also spent a lot of time listening to a lot of different information sources from wildly different perspectives. And I found that this quiet time to listen and to do my own research has then led me down a certain path in my reporting. And that's why this report is going to be a little different today, because I'm going to try to fill in the parts of the news that I see others skipping over that's really preventing us from having a more complete conversation about the history that we're sharing. But this is a difficult topic. It's a challenging topic. I have a lot of notes in front of me. I'm going to read from some of them. It's a topic that even the change of one word can really make a big difference. And I want to be as precise with my language as possible, but I also want to recognize that the way that we talk about this topic, it really matters. And so I want to be as respectful and as accurate as possible. We're going to slow down. There's a real opportunity to learn here. And that's possible in most news stories, but it's a really amazing opportunity when we have it with a story like this. And if we value curiosity over commentary, which is our guiding principle at Smarter News, curiosity over commentary, then I let my curiosity lead me back to some of the basics. In the news, we're talking a lot about Constitution, the amendments, the process, the legal process, but we're not slowing down to define any of that. And I don't know about you, but I certainly need to review that. There's some from high school civics class that hasn't traveled with me as well as I'd like it to. And as a journalist, you get this opportunity to kind of go over this stuff on a regular basis. That's very unique about our career, but not everyone gets that opportunity. So I really want to go back to an opportunity here to learn a little bit more about America and tackle the fundamental questions that have always made America a truly unique and important nation. And that's what we're doing here with this news story. That's why this story is really important. You know, like so many stories we cover, when we strip away the details, we pull all the details away, at the core of this story is a fundamental and really important question. And that very basic, simple question is, am I free? Am I free? What defines your liberty? Who defines it? Who grants it? How do you maintain it? Who protects it? Is it your federal government? Is it your state? Is it your city? Is it your faith? Who do you outsource it to? Who secures it for you? Are you free? Are you free? That's the fundamental question at the center of this story. And I know as a journalist, because I'm guilty of this in the past, of covering a story completely accurately and missing the point. You can cover a story as accurately as possible. You could try your best as a journalist. If you do not go down to the basic question at the center of the story, you will miss the point. And I do not want to miss the point here. The question at the center of this story is, are you free? Are you free? How do you define your liberty? Jackson's Women's Health Organization, that's the clinic in Mississippi, by the way, that performs abortion. It's the only clinic in Mississippi that does so. Jackson is now famous in the case, Dobbs versus Jackson. They have this up on their website as of Monday morning, 72 hours after the ruling. I'm going to read this quote. No woman can call herself free until and unless she decides when or whether she can become a parent. That's one perspective on freedom. What makes us truly free is a fundamental question Americans have grappled with since day one. And our constant churning over what it means to be truly free is at the center of so many of our stories. If we step back far enough to respect that, we see that. Think about it, whether it's voting rights, gun rights, vaccine mandates, that's a great example. Those are all at the core of a lot of those stories is this question of what does it mean to be free in America? Like, what does it mean to be free? It's a big question. It's an important question. And we're going to report on it respectfully today. Here's one little announcement, little side note. I want you to think about this too. We may approach that question of what it means to be truly free differently, but the pursuit of the answer is what actually unites us. And we should not lose sight of that. Because the tension created by the debate gives us the opportunity to create. I know that rhymes. I'm not going to rhyme throughout this whole report. But I want you to think about it that we're going to come at that question of are we truly free from very different perspectives. But our passion behind finding the answer is what unites us. The pursuit actually unites us. And I'm taking some peace in that while I watch the debate rage. That tension is part of the foundation of America. The founders wanted a tension between the federal and the state, between the people, because the tension is where you can get to that next level. So let's not shy away from these hard questions, and let's not shy away from some of the tension. And let's keep in mind that we're all helping each other refine our own answers to that. You know, when you're challenged, you get to refine how you really feel about something. So we can look at this as an opportunity. So let's return to the ruling, though. With some of that just said, let's return to the ruling here. Simply put, the Supreme Court answered this question about who defines your liberty on the issue of abortion and said who defines your liberty is not the Constitution. It's actually the state. This matters because it changes abortion law in America as we know it. It is true, as some say, that this does not make abortion illegal in the United States. However, it does give a state the opportunity to make abortion a crime. And so it depends on how you're framing this, on how it's being presented and how one might feel about it. It's also very rare, a constitutional right like this, where there's a landmark case where a constitutional right is established through a decision. Like I said, it's the previous ruling put abortion underneath this umbrella of the Constitution, right? It's rare to see that and then see it overturned. We don't have a lot of examples of that. The Supreme Court can overturn past decisions. You know, that happens, certainly. But when it's a landmark decision like this, we don't have a ton of examples. You know, one of the most obvious ones you're likely hearing a lot about is Brown versus the Board of Education. That overturned Plessy versus Ferguson, which established segregation. Brown versus the Board of Education did away with segregation. So that's a big one, right? But we don't have a ton of examples like that. And so that's why this also matters beyond just the simple issue. I don't want to say simple issue, but beyond just the issue of abortion. So let's do something different. Instead of starting with abortion itself, let's start here. What is a constitutional right? What is a constitutional right? It's actually a term that can be used in a lot of different ways. And depending on how you use it, it may frame your thinking on the story a lot differently. So I wanted to go into it. A constitutional right is what I am granted as simply an American citizen. You know, I think about it as life, liberty, and the pursuit of happiness, but it's important to note that that was marked out by the Declaration of Independence, and that phrase is not in the Constitution. Life, liberty, and the pursuit of happiness is not in the Constitution. There is no constitutional right to happiness. I hate to be the bearer of bad news, but I did confirm that this weekend. The Constitution starts with this, and I'm going to read it here. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The Constitution really provides a structure of government. It talks a lot about the powers of the presidency, the courts, etc. It's the Bill of Rights, those amendments to the Constitution that really fine-tune the rights of what it means to be an American citizen. And you know some of these, obviously, right? The First Amendment grants me the right of freedom of speech, of press, of religion. There was an original 10 amendments, and then we know that amendments have later been added. The Constitution was amended to include the 19th Amendment, which secured the right of a woman to vote. But what's considered a constitutional right sometimes is less explicit. It's not so clearly stated, like the 19th Amendment, for example. It can be argued depending on your point of view, or it can be argued many times in court about what's implicit in the Constitution, what's not said literally, but what it actually means. For example, a modern debate that we've heard a lot about is healthcare. Some people believe healthcare is a constitutional right owed to a citizen based on, the Bill of Rights, based on simply being an American citizen. Others disagree with that and say that it has nothing to do with being a citizen, that it's a privilege, not a right. And so that's an example of a debate between explicit and implicit. Whether something is implicit or explicit in the Constitution has been a matter of debate since the founding of America. In that way, what we're experiencing is not really new. It's also been a matter of great legal debate since the beginning of America. How literally do you want to read the Constitution? How much do you want to apply modern questions or modernity to a text that's dating back centuries? Does it have to be literally written into the Constitution to be granted as a constitutional right? You get it. There's a lot of debate over that. That debate isn't new. It's not specific to this particular Supreme Court decision that we're going to be looking at. And what's interesting is that the Constitution establishes the Supreme Court and says, hey, the reason for the Supreme Court is actually to uphold the Constitution. So that's kind of interesting, right? We know that the document in and of itself that's creating the Supreme Court is also what bedevils the Supreme Court at different times. What the Supreme Court's job is to do is to not only decide these huge issues of constitutionality, but to try to resolve cases that haven't been resolved in lower courts. It's the highest court in the land. And what they're really supposed to do is protect the Constitution at every turn. They're supposed to stand up for the Constitution, the Supreme Court. And the Supreme Court has had 3 major decisions about abortion. And we talk about all of these like we all know them. But I don't know about you. Again, there's some specifics of these rulings like Roe v. Wade that maybe I never learned or difficult to remember. And so I just want to go over them here because I think this is really important to know. So let's start with Roe v. Wade, okay? Roe stands for Jane Roe. Jane Roe is a fake name. The woman at the center of this case, her first name is Norma. And she wanted an abortion in the state of Texas, where abortion was criminal in most circumstances. Not all circumstances, but in most circumstances. So she wanted this. Henry Wade of Roe v. Wade was the top prosecutor in the Texas county where this was all going down, which is Dallas. And that's where Norma was living. And he would presumably be the one to prosecute this crime. So that's why he was named in this case. Although a recent report in the Washington Post said he wasn't particularly interested in abortion before or after this case. He didn't have anything really to do with this case at all. You're going to see that this is a repeat pattern. So Jane Roe sued Wade for her right to an abortion, and she won. And this is what established the first ruling that established abortion underneath the umbrella of the Constitution. That's what started it. Then you have Planned Parenthood versus Casey. Planned Parenthood of southeastern Pennsylvania sued the Pennsylvania governor, Governor Casey, of Casey in this case. He had signed legislation into law that would require a woman to do a few things before she actually got an abortion. That included informing her parents, or telling her husband, or waiting 24 hours before getting an abortion. And the Supreme Court ruled mostly in favor of Planned Parenthood. It did allow some of this to stand, by the way, but it further reaffirmed Roe v. Wade in a very significant challenge. And so that's why it's often mentioned. You hear Roe v. Wade mentioned often in the news, and then you hear Casey. This is why it's mentioned together. And I'll explain a little bit why these rulings are mentioned together in just a moment. Then you have Dobbs versus Jackson. Thomas Dobbs is a doctor. He's probably a doctor that never thought he'd find himself in this sort of a case. And in fact, he's not involved in this case at all. Dobbs is the top health official in the state of Mississippi. Jackson is that single abortion clinic in the state. And elected officials in the state of Mississippi passed this law a couple years ago that prohibited abortion after 15 weeks. It never went into effect because it was instantly challenged, but that's that's why Dobbs is listed here, because he's the top health official, but he's not involved in this case at all, sort of like Henry Wade. He's just the name that's listed because this is the state of Mississippi that passed this particular law. So he had nothing really to do with this, which again, here's these names that are ingrained into our conversation, our story on this. And yet, those individuals specifically did not have a lot to do with these cases. So the Supreme Court decision on the case Roe v. Wade confirmed a woman's right to access an abortion, not because it was explicitly written into the Constitution, but because it was implicit, the judges said, in the right to privacy as an American citizen. This right to privacy as an American citizen was seen as interpreted by the judges under the 14th Amendment. The 14th Amendment does not mention abortion. In fact, it does not even mention privacy at all by name. But as the decision in Roe v. Wade maps out, and I'm going to quote here, this is in the decision itself, quote, the 14th Amendment, which protects against state action, the right to privacy, including a woman's qualified right to terminate her pregnancy. So they're saying the 14th Amendment in the Constitution, it doesn't say abortion. It doesn't say privacy, but what it's saying is that a person has a right to pursue liberty, which I'll get to in just a moment, and that includes having the right to terminate their pregnancy. The case in Casey, which is about 20 years later in the 1990s, Roe v. Wade was in the 1970s, it furthers, it further doubled downs, if you will, on the 14th Amendment. And it affirmed this ruling that the state could not infringe upon a woman's personal autonomy as an American citizen, that would violate her liberty protected by the 14th Amendment. So let's stop here. What is the 14th Amendment exactly? And why is it being used so much? The 14th Amendment basically says anyone born in America is an American citizen. I mean, it's an important amendment, but also tucked into it, it's what's called the Due Process Clause of the 14th Amendment. And I'm going to read it here. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. It's that part liberty that the judges argue that the state is depriving a woman of if she doesn't have access to an abortion. But the Supreme Court ruling just announced in Dobbs versus Jackson said this was wrong. This was just a plain wrong interpretation of the 14th Amendment, that this is a misreading. And listen, that's freaked out a lot of people. The Supreme Court decision has freaked out a lot of people, plainly speaking, because the 14th Amendment has been used in a lot of different things to secure a lot of different rights. Let's say to contraceptive, for example, gay relationships, marriage. And so that's why there's a concern about the precedent that this ruling set. And so I want you to know, while you're seeing that reaction, it's not just based on emotion. It's based on precedent and a concern about, well, what does this mean for other cases where the 14th Amendment was foundational to the decision? And that's why that's being asked. But let's go a little further than this, because in order to understand what this ruling does on abortion specifically, we also need to understand the past rulings on abortion and what they actually did. We talked a little bit about it, but there's a lot of misconceptions about abortion law. And I really want to clear these up, because these are misconceptions that I held myself. And I just want to speak honestly here. Here I am, a woman in America. I'm educated. I'm a journalist. I cover a lot of different topics, including abortion, over the past 2 decades. And yet, when I got closer to abortion law in the recent years, where I've really had to research what does abortion law currently say, because we're seeing a lot of challenges to abortion law in different states, I found that my understanding of abortion law in America was actually wrong. And so you might find that you share in that. And that's why I want to just talk a little bit about this, because it's really important to understand what's next. When we say freedom or liberty, oftentimes that means complete unrestricted decision-making, doesn't it? Like, I do what I want when I want it. That's what freedom really is. But the Constitution does not confirm that. Unfortunately, in some cases, and existing law does not confirm that in a lot of ways. It does not confirm that when it comes to abortion. And that's one of the biggest misconceptions about law in America, but also specifically about abortion law. When it comes to abortion, the right of a citizen has generally always been limited for both the woman and the unborn. And abortion is not unique in that particular way. Abortion is unique in some ways, which we'll get to, but it's not unique in that way. Even you could say more agreed upon established constitutional rights, what we refer to as constitutional rights. Some refer to abortion as a constitutional right, but the ones that are most commonly agreed upon have limits. I can't scream fire in a crowded theater. That's not protected free speech. I can't carry a gun anywhere, anytime in America. I actually have to follow state laws or local ordinances. I also couldn't attain an abortion anytime in my pregnancy. That's not what prior law confirmed. That's not protected by federal law. There's no federal law that exists for that. But that's also not secured by previous Supreme Court rulings like Roe v. Wade. That's never been confirmed. So when you see a sign like "My body, my choice," in most states, it's your body, your choice, ... to a certain point in the pregnancy as decided by your state. That's what the law has been for the last 50 years. And one of the reasons for this has to do with the status of the unborn. We're going to use the term unborn. Some will call the unborn a fetus. Others will call it a baby. In the effort to maintain the most nonpartisan delivery, I'm going to use the term that's been used by the courts, which is the unborn. But that's really key. In the conversations I've heard over the last several days, few have focused on the right of the unborn. And the tension between the right of the unborn and the right of a woman has always been part of the abortion debate. It's actually what makes the abortion debate truly unique. When Roe was decided, the Supreme Court tried to give guidance where the right of the mother for her privacy, her autonomy, her expression of liberty, was kind of came up against the right of the state to impact the unborn. At a certain point in the pregnancy, the Supreme Court conceded the state had an interest in the unborn. And so the Supreme Court deferred to the states to limit abortion to a certain point in the pregnancy. It did not give a strict guidance for this. It gave the states some freedom to decide it. And that's why different states have different abortion laws. And that's why you see a lot of different things. That later Supreme Court case, Casey, further tried to define, they tried to figure that out. When is that exact point when the state can add restrictions? And that's when that term viability came up. The state had more standing, the court inferred, when the unborn could survive outside the woman's body. And so the Casey decision said the state could not put undue burden on the woman deciding her fate up until the point of viability of the unborn. When it crossed the line, then the state had more standing to, in lack of a better word, put more burdens or put more restrictions on the woman because the state had an interest in the unborn. That dividing line has always been a challenge for decades. And we see that in this decision that's in front of us. In fact, I have the whole thing printed out. I don't like to waste paper like this, but I know this is something that I'm going to be referring to quite a bit, really over the next several years. We see that both sides, you have the majority decision that made this decision in this particular case, and then you have the dissenting opinion. And you can see that both sides still struggle with this particular issue. The majority in the current decision writes past viability arguments are arbitrary. And arbitrary is not a good word. They're saying this is just arbitrary. Without, quote, much support among philosophers and ethicists who have attempted to justify a right to abortion. It goes on to say, the most obvious problem with any such argument is that viability has changed over time and is heavily dependent on factors such as medical advances. They're saying this dividing line that the courts have tried to do repeatedly, it doesn't work. It's too difficult to determine. It's not what the court's supposed to do. That's the majority. But the dissenting opinion addresses this too, writing that past court rulings, quote, recognize competing interests between the woman and the unborn and sought balance between them. Quote, the constitutional regime, note that term, the constitutional regime we enter today erases the woman's interest and recognizes only the states or the federal governments. They're saying this decision totally tips the scale against the women in favor of the unborn. And so you have these two, you have this debate that's been ongoing, further highlighted in this decision. I know this sounds obvious, But pregnancy is what makes abortion law very unique. And it's unlike other constitutional debates that focus only on the individual. In abortion law, you're talking about two entities. You may call them by different names. You may feel differently depending on your point of view, but there's still two in this particular law. There's still two entities that the law is trying to figure out and navigate. And this is what makes it very different. And what I've noticed over the last several days in the press, both liberal and conservative press, there's been a lot of focus on the right of the woman, but very, very little talk on the right of the unborn. And it is key to this story. If we do not address it, then we are not covering the story as best that we can. This is an obvious bias by the media, and it's uncomfortable. It's really hard, by the way, as someone that's done this, has been live on television trying to tackle really difficult, sensitive topics. It is hard to talk about something like this in 6 minutes and then throw to a commercial break and then you see a Geico commercial. It's hard to really tackle these sort of questions of the unborn and what the state interest is. It's easier to talk about the woman's rights. It's harder to talk about this. And the press does not detail in any way the abortion procedure at different stages in pregnancy. In fact, just mentioning these different topics, because we're so not used to discussing them in any significant way, may lead you to think that I'm actually more pro-life on this issue because I'm even acknowledging it. And I just want to tell you, I don't have an agenda on this topic, but based on my research specifically over the last couple of days, this is the major issue about abortion decisions when it comes to the Supreme Court. This is the sticking point. This is what the courts haven't really worked out. And it's missing in the reporting because it's really, really hard. It's a really challenging thing to talk about. It's hard. It's emotional. It goes to our fundamental beliefs about life. But this is at the heart of what we're talking about. And this also goes back to the question of how do you define what liberty is and who has it? So I think we need to recognize it. And so I want to just put that fine point on that this is something that the Supreme Court has struggled with, and the states through their elected representatives are going to have to tackle. And you're going to see a lot of different thoughts on this. You already have, which is what we're going to talk about now. Because what the question is, well, what's next, right? People are rejoicing about this ruling. They're protesting it. There's a lot of people in the middle that are sort of looking at these both sides and saying like, well, what does this all mean? Like, what is real here? What is real? And there's a lot of what ifs, and there's a lot of what nows and hows and whats. And so I'm just going to list a couple of them here. And we're going to talk a little bit about what questions we should be asking and watching for. So number one, we have more than a dozen states that have trigger laws. These are laws that are going to go into effect either immediately or in some time period after this ruling of Roe being overturned happens. So if it hasn't happened now in a particular state, it may happen in the next several weeks. So watch for that. While we know that that's the case, that these trigger laws do exist that could make abortion illegal in these states, there are some really important questions to ask, like how will that law be enforced? How is it going to be regulated? What will the penalty exactly be in different states? Who will investigate? Is a patrol cop going to investigate this? Is the person that's going to be pulling you over for a ticket going to be looking at this issue? How is this actually done? What is the reality of prosecution? What's the reality of investigation? There's a lot of questions on this. So you got a big headline, but the practicality of applicability is really important. Number two, what does this mean for medications? Contraceptives, for example. What about emergency health care? For example, most suggest that procedures or prescriptions for miscarriages would not be included in these restrictions. There can be similar procedures or prescriptions for miscarriages as there have been for abortions. So you're going to get different opinions on what that looks like. What I wanted to point out, though, is you do have a recent abortion law in Texas that has shown that in practicality, healthcare providers have struggled with navigating this. Even though it may seem very clear on paper of what's included and what's not, healthcare providers are trying to figure this out while continuing their practice. And it's not just a political question, it's also a practical question. If you're a doctor performing procedures and you're wondering what this new world looks like, What are you going to be willing to do? If you're a pharmacist, what questions are you going to be asking? These are some of the things that were experienced in Texas as Texas passed a new restrictive law recently. And number 3, what about federal laws? Federal laws that would look to codify or confirm abortion access. What about that? If the federal government did this, how, first of all, is that even possible? Is that even possible for Congress to work through? It doesn't seem likely right now, but Congress will change. So could you see a federal law in the future that does this? Of course you could. What does that actually mean though? For example, does that mean federal land could have abortion clinics inside states where abortion is criminal? And how would that work? I can't answer all of these questions. And in fact, I think sometimes I think we need to talk about them, but entertaining them further can also be a disservice because we don't actually know some of these things. We're going to have to wait. We are in a new world. We're in a new territory when it comes to this. And that means there's going to be some more chaos before there's clarity on a lot of these issues. It's just going to take some time to work out, and it's going to be very specific to what state you're in. So I want to mention these couple things to consider. I like this kind of topic of like something to consider. So something to consider while you're watching this story to develop. The reality is not going to be the same for everybody. It never has been either. And that's important to know. Remember, past precedent in the court, it wasn't the same for everybody. Abortion law looked a little different depending on what state you lived in. It's going to continue to be that way. Your experience will 100% depend on where you live. Not just the state, but the city and the county as well. And for the most accurate information, I would really prioritize local news that really is in tune with the local community and also elected officials. Most of the what ifs are going to be handled by the state and elected officials. And those in power, though, are not permanent. And that's important to mention here. They're elected. And that means whatever the reality is today could actually change. And that's why there is a hesitation in me to go down the paths too far, because we have a big election coming up in November, but we also have elections at a local level that could really impact this. We've seen this move in Texas, by the way. Let's just use Texas as an example. Texas recently passes this very restrictive abortion law. And we've seen this in the Texas elected officials. For the last decade, Texas has been moving these laws further along, and one finally ended up passing. But Texas is changing. We've seen that with the pandemic, the rush of people from other states to Texas, and the pendulum could swing in the other direction. That's one of the arguments made to defer to states, is that the elected officials most closely represent the people that are living in those states and how they define liberty and freedom. Justice Clarence Thomas and what he wrote on this particular issue has been getting a lot of attention. And I think it's important because a lot of people are pointing to him as an ominous voice on how this ruling will affect other big issues. In fact, I was listening to one podcast that said his ruling, his concurrence in this decision was nightmarish. And then I listened to another podcast that called it fabulous or like fantastic. So there's, again, a lot of different opinions on this. But as I was reading what he wrote, I thought this line was particularly important. He wrote, quote, "The right to abortion is ultimately a policy goal in desperate search of a constitutional justification." Let me read that again. "The right to abortion is ultimately a policy goal in desperate search of a constitutional justification." So think about that. If you're in line with that thinking, policy is a subject of politics. Politicians matter. And so does voting. So that's something to think about. Number 2, while you are going to see a lot of attention placed on states that may have these trigger laws or have put more restrictive laws into effect, we really have to remember that we're also seeing states expand abortion access. We've seen this trend as well over the last several years. And we can't forget that that's part of the story. So you have what would be described as severe restrictions, and then you have severe expansions of access. And it depends, again, on where you're living. In a state like California or Illinois, for example, or New York, there was a recent law passed in New York about abortion access. We covered that on SmartHER News a couple years ago. It allows abortion after viability. Remember, after that point of viability as mapped out by the Supreme Court and Supreme Court precedent. So it allows abortion if the fetus or unborn or baby, however you want to describe the pregnancy, is no longer viable, or if the woman's life is in danger, and that includes her mental health. So that means in the state of New York, an abortion can be performed and this is how some have described it, up into the very last point of the pregnancy, if a doctor and the woman determine that her life is in danger, including her mental health. So while the focus is a lot on these states that are limiting abortion, and that's really important, I also think it's important to balance that out with the states that are moving to expand it. And the question is, what role does government truly play in this new era? Government is only one role in this. And we're seeing that. We're seeing companies, big companies, make statements after the Supreme Court decision about how they're going to support their employees access abortion, even if they're operating in a state where it be restricted. I also think we have to add in, well, what is going to be the role of nonprofits? What is going to be the role of churches, faith groups? What is this all going to look like? It's not just all about the government, or is it? And that's what I'm going to be watching. Again, the applicability of what's to come is really to be determined. And there's currently not that groundswell in Congress needed to pass a federal law. Not right now, but that doesn't mean it would never happen. And finally, I think this is really important to consider. The Supreme Court, I know there's a lot of focus on the justices who made that decision. And rightfully so. It's a historic decision. But the Supreme Court doesn't just stumble upon cases and just rule. Cases have to be brought to the court. In the case of this Mississippi law, the law passed in 2018. It was several years ago. And we saw it work, the challenges to the law work its way up until the point that it got to the Supreme Court. And the Supreme Court still had to decide whether or not the Supreme Court was going to take up the case. There are thousands. I think the estimate is like 7,000 cases come before the Supreme Court every single year, and you get like 100 cases that actually go through the Supreme Court. So I add that as well because while it's important to watch for future challenges on abortion, or you're hearing about, well, what about future challenges on things like same-sex marriage or contraceptive? There will really need to be the right circumstances for that legal challenge to even enter a courthouse, let alone the Supreme Courthouse, because the rulings have passed precedent. It's going to make it more difficult. Doesn't mean it's not going to happen. We saw it with abortion, but how fast it could happen and what would be the specifics are going to be really, really critical. So I think that's important to note. There's a lot of people pointing fingers and placing blame on why we're here. Why are we at this point in history? And again, some are celebrating it, some are criticizing it. We're seeing all the gamuts of emotion. And we're seeing all of it right before we're celebrating Independence Day for America. And I think there's something very poetic to that, ironic and maybe poetic here. While there's a lot of finger pointing, I think it's also important. This is difficult because it's always difficult to realize this, but ultimately it's the American people who made this decision. American people elected presidents who appointed certain Supreme Court justices, and not just recent Supreme Court justices. This is the makeup of the court. This is the makeup of the court over many, many years. People have elected certain state representatives. Those state representatives have passed legislation either to expand abortion or restrict it. These people just didn't appear. The Supreme Court just didn't appear. The case just didn't appear. The elected officials didn't just appear. This all came from choices made by the people in the United States. And so that's an important reminder as well that your vote matters and your role sometimes doesn't feel very big, but it does matter in this. So let's go back to our premise and this question. I'm curious how you think about this now as we've kind of reviewed some of the real fundamental parts of this story. Are you free? Are you truly free? How do you feel about that question now? How do you feel like this case, whether you're a man or a woman, how that impacts you, or how we're defining an American citizen and liberty? Who defines your liberty? Is it the Constitution? Is it your state? Is it your city? Is it your faith? Who does it? Any of them? I maintain optimism. It can be difficult at times when you work in the news industry, but that the conversation is going to lead us to greater freedom. I think we're in the process of establishing greater freedom because we're able in the United States of America to pursue the definition of freedom in the open. And that's not the reality of a lot of places. And we can lose sight on that as we get distracted by, emotions, which I know are running really high. But the more challenges that we see to each other, the more affirmed that I believe that we're actually on the right path. Again, that the tension is creating the next step. Fire doesn't appear from just anything. It has to be ignited. Intention is what ignites that. So I'm going to maintain optimism over that. And that's how I continue. That's how I continue my work. That's why I believe in nonpartisan news too, because the exercise of nonpartisan news, presenting more information rather than a political agenda, is my expression of what it means to truly be free. I think that's really important to us seeking the freedom that we all want. We all want to be free. We all want to feel free and to feel in full power of our liberty. And so I believe that freedom of the press is really critical to that. And so what I'm doing right now is an exercise of my freedom on a regular basis. I look at a lot of news sites, and I started to think about this weekend. I see them as prisoners to their partisanship because they have to maintain it. That's not freedom. That's something different. And so I look at what we're doing at SmartHER News, and I see liberty. I see liberty. And that's why it feels different. And that's why we see news differently. We want to free up your time so you can live your own story. That's what we want for you. A free press, a free people. A free people more able to ask the questions to further define what does it mean to be free. We want you fully equipped, whatever your point of view, refined and equipped. I know it's not easy, and I feel that too. It's not easy, but we're called for these times. When I started SmartHER News, I was just hoping to be helpful. I didn't think that we were going to go through like a 100-year pandemic or the upheaval of the 2020 election or the withdrawal of Afghanistan or a landmark Supreme Court decision. These are not the things that I thought were coming down. I knew that anything can happen in the news, but these weren't one of them. These weren't some of the things that I thought about. And so I hope that we are helpful during these times. And I think that we're called for this. I feel a great purpose in this and a great privilege in being part of news delivery during this time. And that couldn't happen without you. And I'm really grateful for that. It's an honor and it's a privilege. And I mean that. And I'm very grateful. So there's more on this topic. We could go another couple hours, but I wanted to just give you this foundation in the hopes that it helps us for our next segments on it, how we approach this topic next, because the story can go in a lot of different directions. And now we have a starting point together. So thank you. Thank you for sharing this time with me. And we'll have more on all these stories on smarternews.com. I'll see you soon.